Donna is the Senior Legal Policy Advisor at the National Association of Wetland Managers, collectively called NAWM. So NAWM members include states, tribes implementing Clean Water Act as co-regulators with the federal government. Donna served as the jurisdiction team lead in the US EPA's Office of Water from 1998 to 2020. She worked on a variety of issues at EPA with the focus in recent years on the geographic scope of the Clean Water Act in light of the US Supreme Court decisions. Prior to joining EPA in 1998, Donna worked for the US Congress Office of Technology and Assessment and in private law practices. She has a BA magna cum laude from Harvard and an MPP from the University of California at Berkeley and a JD cum laude from Georgetown University Law School and an LMM in environmental law summa cum laude from Georgetown University Law School. That's a lot. Having talked to Donna, all those letters behind her name and her accolades really are very apparent. Amazingly smart, and I'm really excited to have her here. Just to finish, Donna has been an adjunct professor at George Washington University Law School since 1996, teaching environmental law. In what's left of her time, she moonlights as a professional potter and an unprofessional horse trainer. So Donna, if you can share your screen.
Yep, it claims that I am sharing. After all those accolades, we'll see if I can get the technology to work it.
Yes, and will you go back to your title slide? Perfect.
Yes, indeed. All right, well, thanks, Steve. And thanks to everybody for inviting me to speak to the Montana Wetland Council's meeting today. I wish I could be there in person. I grew up in southeastern Washington, and when visiting Montana, I feel like I've come home. So as Steve indicated, I'm going to be giving a brief overview of the issue of waters of the United States, or WOTUS, as most of us know, and the aftermath of the US Supreme Court decision in Sackett. My goal is to provide the national level sort of baseline for the subsequent presentations today. Specifically, I'll talk about what the Clean Water Act says about what waters and wetlands it covers, and how EPA and the Army Corps have further defined this threshold question by defining WOTUS and regulation. We'll look briefly at some of the key issues raised by WOTUS that continue to resonate today through the many court cases and regulatory definitions we've seen. We'll give an overview of what Sackett held, what the current definitions of WOTUS are. You'll notice that's plural, which is part of the alarm, and how those have been shaped by ongoing litigation. And I'll close with a discussion of the variety of responses to Sackett that NAWM has been seeing from its state and tribal members, and then planning to leave plenty of time for questions. So let's launch, but first, how is the sound, and can you see my slides okay? Keep going. Any thumbs up there?
I think it sounds okay and looks good.
All right, good. All right, on we go. So, Clean Water Act. Some of this is going to be very baseline. I knew this when I was in high school level, but perhaps not for everyone. And I'll be quick with the background. The Clean Water Act, as we know, is the federal primary federal statute protecting the nation's waters. And that said, Clean Water Act does not protect all waters and wetlands. It didn't even before Sackett. Congress defines the term navigable waters, the term used in the statute, as waters of the United States, including the territorial seas. And that's all Congress said about this key threshold term. If a water is a WOTUS, then it's protected by the Clean Water Act's regulatory provisions. If it's not a WOTUS, then those waters aren't regulated. And at any rate, EPA and the Army Corps of Engineers have further defined WOTUS by regulation, hoping to provide the level of detail necessary for federal agencies, states, tribes, localities to implement Clean Water Act programs. And EPA and the Army Corps have developed regulatory definitions of WOTUS several times, often in response to US Supreme Court decisions. The pace of court decisions and new regulatory WOTUS definitions have accelerated in recent years, making WOTUS a controversial and frequently changing concept. Primarily, there's a lot of different issues in WOTUS, but particularly controversial issues have included, for example, the extent to which streams and other waters that flow only after rainfall are protected, those ephemeral streams and other waters. What extent do wetlands that don't immediately abut tributaries receive protection under the Act? Are geographically isolated waters and wetlands protected? And what waters and features are excluded from waters of the U.S.? Those are among the main issues that get the most attention, debate, and act as a source of controversy in the definition of WOTUS. Also part of the debate about WOTUS has been the relevance of science to the regulatory definition of WOTUS, and that has changed over time depending on the definition and the administration putting that definition out. The most recent U.S. Supreme Court decision about WOTUS was the May 2023 Sackett decision. And current definitions of WOTUS reflect Sackett. And as we'll see, and I suspect many of you know, Sackett is not good news for protection of streams that flow less than seasonally and for wetlands that lack a surface connection to a seasonal tributary. So what did Sackett hold? Sackett focused on wetlands, but the decision and the standard for when a water or wetland is a water of the U.S. that it endorses also affects when streams, lakes, and other types of waters are jurisdictional. So it's broader than wetlands. Estimates from EPA and the Army Corps indicate that nationally, over half of previously jurisdictional wetlands are now unprotected by the Clean Water Act. And over 70% of rivers, lakes, and streams, particularly in terms of stream miles, have no or uncertain protection. So Sackett was a big hit. The Sackett opinion consists of a lot of block quotes from the Supreme Court Justice Scalia's opinion in the 2006 Rapanos case. That's important because EPA and the Army Corps have over 17 years experience implementing Justice Scalia's relatively permanent standard for identifying WOTUS that came from Rapanos, along with Justice Kennedy's significant nexus standards. And so we and the agencies have a base understanding to build from and predict what might happen under a relatively permanent standard. Now, one of the clearest holdings in Sackett is that the significant nexus standard is no longer appropriate for identifying WOTUS. Instead, the court adopts Justice Scalia's relatively permanent standard. And as a result, first and foremost, after Sackett, WOTUS includes relatively permanent water bodies that connect to an interstate traditional navigable water. And to be relatively permanent, water doesn't have to be present at all times, but generally has been interpreted as flowing at least seasonally. Now, agencies since the Rapanos opinion came down in 2006 have interpreted seasonally as varying from region to region without a strict threshold such as 3 months. Woe to you if you have 89 and not 90 days of flow. It varies from region to region. There's no clear threshold. With respect to wetlands, Sackett holds that wetlands are jurisdictional as waters of the United States if they are as, quote, a practical matter indistinguishable, end quote, from a WOTUS to which they are adjacent, and, quote, have a continuous surface connection to that water, making it difficult to determine where the water ends and the wetland begins. In practice, to be WOTUS, these wetlands have to have a continuous surface connection to a relatively permanent water. It's interesting to note that the opinion and the agencies over time have not said that the connection has to be a continuous hydrologic surface connection. And since Rapanos, EPA and the Army Corps have viewed that connection as present, even if the hydrology dries up for some months of the year. So you need a continuous surface connection. Waters that are less than relatively permanent, such as ephemeral streams, are not considered WOTUS under Sackett, as are waters that and wetlands that don't connect to a traditional navigable water. Importantly, Sackett did not change states and tribal authority under the Clean Water Act to be more environmentally protective than the federal program. And this authority likely will become key in the post-Sackett world as states and tribes seek to fill the gap in federal protections. In January 2023, EPA and the Army Corps defined WOTUS in regulation. In September 2023, a few months after Sackett was decided, the agencies revised that definition to reflect the Sackett decision. And as is typical for WOTUS regulatory definitions, the 2023 definition is indeed being challenged in court, both its original and then amended to include what it talked about in September. As a result, the pre-2015 definition of WOTUS is in effect in slightly more than half the states, including Montana. And we'll talk about that in a moment. WOTUS regulatory definitions define what waters are waters of the United States and what waters are excluded from waters of the United States. And here's on the screen is there a paraphrase of the 2023 regulatory definition as revised to reflect Sackett. And as you can see, WOTUS includes a variety of categories of waters, traditional navigable waters, including the territorial seas, interstate waters, amended after Sackett, by the way, to not say, including interstate wetlands, impoundments of jurisdictional waters, relatively permanent tributaries. There comes that key phrase, relatively permanent. And wetlands that have a continuous surface connection to a relatively permanent water, and then relatively permanent lakes and ponds that also have a continuous surface connection to a relatively permanent water. The 2023 definition of WOTUS has 8 exclusions, 2 that have been around for a long time, one for waste treatment systems, and another for prior converted cropland, a term that arises initially in the Food Security Act. They also, in addition to those 2, the 2023 definition includes other exclusions such as areas that are artificially irrigated and would dry up if irrigation ceased, ditches draining only upland and having less than relatively permanent flow, among others. And even if a wetland or other water would fall into one of the categories of included as waters of the United States, if it's listed as excluded, it remains a non-WOTUS. So, and essentially, B trumps A, okay? So that's the 2023 WOTUS regulatory definition is amended to reflect Sackett. Ongoing litigation, as I said a moment ago, means, however, that the 2023 regulatory definition is not in effect in 27 states, including Montana. So what's up? You've probably seen this lovely little map from EPA's website. The 2023 regulatory definition of WOTUS is being challenged in federal district courts in Texas, Kentucky, and North Dakota, and Montana is one of the litigants. Some of the courts have put a stay on implementing the regulatory definition while they consider that definition's validity, while the definition remains in effect elsewhere in those states that are not among the litigants. And as a result of that ongoing litigation, currently the pre-2015 definition of WOTUS, interpreted consistently with Sackett, is in effect in 27 states, including Montana. And the 2023 definition of WOTUS is in effect in the other 23 states and on tribal lands. And here's a map that EPA has on its WOTUS website showing what definition is in effect where. And there are those, myself included, that are slightly appalled that this key threshold definition is really best described in a lime green and purple map, but that at the moment is the case. Both pre-2015 and the 2023 definitions are interpreted in light of Sackett. And as a result, the definitions don't seem widely different in what waters are considered to be waters of the United States. For example, the requirements for relatively permanent flow and a connection to a traditional navigable water are the same for the pre-2015 reflecting Sackett and for the 2023 revised rule. Under both definitions, a wetland has to have a continuous surface connection to a relatively permanent water in order to be a WOTUS. Under both definitions, a WOTUS isn't a WOTUS, wetland rather, isn't a WOTUS just because it's interstate. I think one of the key definitions is the list of waters excluded from WOTUS. The pre-2015 definition only lists waste treatment systems and prior converted cropland as excluded from WOTUS. And as mentioned a moment ago, the 2023 definition includes 6 additional exclusions, in addition to waste treatment and prior converted. I think another key difference between the revised 2023 rule and the pre-2015 rule is that there's a whole regulation and associated preamble describing the 2023 definition in light of Sackett. In contrast, no regulation or guidance yet describes exactly what it means to apply the pre-2015 WOTUS definition consistently with Sackett. And that can be a source of uncertainty. I have a couple of examples here on the slide of possible sources to help interpret applicable WOTUS definitions to reduce that uncertainty about what the scope is and what interpreted in light of consistently with Sackett might mean. As I mentioned earlier, EPA and the Army Corps have been applying Justice Scalia's relatively permanent standard since 2006 as one of two then applicable standards, along with significant nexus. And as a result, agencies issued guidance and have considerable implementation experience with the relatively permanent standard that is likely relevant to the pre-2015 WOTUS definition implemented consistently with Sackett. EPA makes this post-Rapanos guidance and implementation practices available on its website at epa.gov/WOTUS. The agencies more recently also have given moderately detailed webinars that were recorded and posted online, interpreting the pre-2015 definition consistent with Sackett. And these information sources should be useful in interpreting the scope of WOTUS under the pre-2015 regulatory definition, as is called for in the state of Montana. The material also may be relevant to implementing the 2023 rule. Another interesting source of data that I have fun playing with is a website maintained by EPA based on data from the Corps' approved jurisdictional determinations, or AJDs, including all of those completed since August of 2015. And it could prove helpful when making a jurisdictional determination, or more generally deciding if this might be a jurisdictional wetland or other water, to know if a nearby stream or a wetland complex has already been found to be jurisdictional under the relatively permanent standard. And on this JD website, the user can pick the geographic area of interest as well as under what standard was a JD made. And this website, as you can see here, can also be found at epa.gov/WOTUS. It's based on Google Earth, so even a non-GIS person like myself can navigate the site and not just get frustrated. So anyway, so those are some possible sources of interpreting what's going on with the Sackett version of the relatively permanent standard. Shifting gears slightly, how have states and tribes responded to changing WOTUS definitions? As we all know, states and tribes have to continue operating programs to protect wetlands and other waters every day, even as the scope of WOTUS evolves. And as a result, a number of states and tribes have focused efforts on data collection and field and analytical tool development that aren't tied directly to a specific WOTUS definition. And the hope seems to be that these efforts would have a longer useful shelf life and not be out of date with the next interpretation of WOTUS. For example, some states are refining and further mapping their wetlands and other waters and assessing their condition. Other states are assessing connectivity relationships among their waters and to traditional navigable waters. Some type of connectivity is an element in all WOTUS definitions since Rapanos, such as acting as a tributary or affecting a downstream water's integrity. That's the now no longer allowed significant nexus analysis. So understanding more about connectivity is likely to be of some use in the future. Some states and tribes are assessing the functions and values of their wetlands, and many states and tribes are expanding their education and outreach efforts, particularly regarding the benefits of protecting wetlands and waters. As we all know, water resource protection programs work best when the public understands why such protection is important, both to the state and to themselves. What are states doing in response to Sackett, sort of in response to the fluctuating definition of WOTUS? Many states are evaluating the extent to which waters of the state, some of them, are now unprotected by the Federal Clean Water Act after Sackett. For example, They are, Colorado is in result of their evaluating what waters of the state might no longer have federal protections, is they're expecting their legislation, their legislature to be considering legislation this spring that expressly is intended to help fill the gap by setting up a state level permitting process for newly non-WOTUS waters. Proposals from the Colorado Department of Health and Environment emphasize that they are intended to preserve the status quo and not go beyond the scope of what was federally protected prior to Sackett. For example, Colorado has said they're interested in protecting its many groundwater-fed wetlands such as fens that lack required surface water connections that under Sackett are necessary to be considered WOTUS. Similarly, the state of New Mexico is evaluating the potential of setting up a new statewide program requiring permits for discharges into all waters of the state, including those that are not WOTUS. NAWM has heard that some state legislatures are addressing the scope to which wetlands are protected. Some are considering legislation that would expressly say wetlands that are waters of the state are protected. Others, however, are trying to limit protections for wetlands, essentially mirroring the Sackett decision. One approach that's being evaluated and in some instances taken is to enact what's called a no more stringent than provision, one that prevents state requirements from being more environmentally protective than the federal minimum requirements. That would prevent a state from filling the gap in federal protections. Before Sackett, over half the states and many tribes relied on Section 401 water quality certification as their primary means of protecting wetlands and other waters in their state. And Section 401, as I think probably many of you know, allows states and tribes to shape federal permits and licenses that would authorize discharge into a water of the United States. After Sackett, since there are fewer permits and licenses required because the scope of WOTUS has been reduced, 401 doesn't serve that purpose as well as it did before the Supreme Court decision. And several states and tribes are considering creating requirements under state or tribal law for evaluating a project's consistency with water quality goals and other requirements similar to those that are considered under Section 401. Several states have strong wetlands programs, either regulatory, non-regulatory, or in many instances, both. But they're concerned that a reduced federal presence after Sackett will require the states to increase its regulatory and non-regulatory efforts to protect wetlands and other waters of the state. For example, Washington State's Department of Ecology estimates that at least 50% of the state's wetlands are no longer WOTUS. They are, of course, still waters of the state. Sackett didn't change that. But nonetheless, as a result, Washington Ecology anticipates it may have to process an additional 50 to 100 permits a year from the 12 or so it currently handles, those having been handled by the U.S. Army Corps of Engineers prior to Sackett and now no longer. I could continue on, but I think I'll stop here in order to have plenty of time for questions and comments. So I'll put that picture up, which is incidentally Western Massachusetts, and see what we have.
Thank you, Donna.
Mhm.
And we will open it up for questions. If you have a question, there's microphones placed on the outsides of all the rows. I'll start out with one quickly. Donna, can you just explain, since Montana is under that pre-2015 rule, what those 6 exclusions that are no longer, that we do not have, what those are and what that might mean?
Okay, let me see how many I can get. Both definitions in effect include that for prior converted cropland and waste treatment systems. Those have been in place since PCC came in 1992 and waste treatment in 1980s. So they've been around a long time. The additional exclusions in the 2023 rule mirror those in the 2015 rule. And if you're starting to hold your head because of all the different rules floating around. That's WOTUS, right? They reflect longstanding practice by the agencies that were not enshrined in regulation. And so in 2023, they put them in regulation. They include areas that are artificially irrigated and that may dry up should irrigation cease. It includes ditches that have less than relatively permanent flow and drain only uplands. It includes, and I wish I had my definition, my regulatory definition on my desk. My cat's sitting on it in the other room, and he's big enough, it's hard to get it out from underneath him. So let me think. It addresses barrow pits. You know, I am going to bring it up on my screen. I'm going to, actually, I'm going to not be that cute. I am going to bring up the definition so I don't give you the wrong stuff. And now I have a bigger picture of you all, and I appreciate that. But I can do this moderately quickly, and sorry for the delay. Documents. But the again, it's important to sort of view the exclusions as in capturing in regulation the long-standing practice that the agencies had. What long-standing means? They were listed in a preamble by the Army Corps in 1986 as examples of waters that generally weren't waters of the United States. And that was repeated again in here we are. By EPA using the same examples in 1988. And it was thought that it would be helpful to put those in regulation and not say generally. Unlike in the preamble language, these are not waters of the US. And in addition to waste treatment and prior converted cropland and relatively permanent ditches and artificially irrigated areas, you have artificial lakes or ponds created by excavating or diking dry land to collect and retain water used for purposes such as stock watering, irrigation, settling basins, or rice growing. Another example is artificial reflecting or swimming pools or other small ornamental bodies of water created by excavating or diking dry land to retain water for primarily aesthetic reasons. Another example is water-filled depressions created in dry land that are incidental to construction activity, and pits excavated in dry land for the purposes of getting sand, gravel, and the like, unless and until the construction or excavation operation is abandoned and the resulting water meets the definition of waters of the US. And then the eighth example is swales and erosional features and they give us an example, e.g. Gullies and small washes that are characterized by low volume, infrequent, or short duration flow. It's important to note again, as I said earlier, that these are considered not to be waters of the US, even where they otherwise meet the terms of the categories of waters that are waters of the US. So B trumps A.
Thank you. Bryce first, and please introduce yourself and who you're with. Donna, can you hear him?
I can't, but I see a lot of people looking up. Am I like some massive head in the front of the room?
Okay. I might not be using it right.
Try this one. See if that goes in your-
Can you hear me? There we go.
I can, that's perfect.
My question is regarding the squishy words, relatively, continuous,
Mhm.
and continuous in time versus continuous at one point in time. And then the
Mhm.
last one is prior, with those exclusions and prior converted. Is there a date on prior, or are we just moving forward and the interactions of those allow continued movement of wetlands to be converted to cropland and
Yeah.
then become prior?
Prior, as I mentioned, I'll take them in reverse, and I might not get all the ambiguous terms, of which there are indeed many. I think it's actually fortunate that the Supreme Court didn't go in great detail as to what each of those words mean, because it wouldn't have been informed by science or practice, and we might not like the result. But prior converted is an idea that comes from the Food Security Act in 1985, often called the Farm Bill. And it indicated that areas that were converted from wetlands to grow commodity crops prior to, I believe it's November 1985, that's, I believe, when it was enacted, are considered excluded from the definition of waters of the US and any regulatory requirements that come with that, unless they are abandoned, which means that it hasn't been used to grow commodity crops for sort of 5 years. And that's the approach that the agencies have interpreted. Occasionally, it sounded as if a change in use, I think I'll grow a shopping mall or something, was required. But currently, the agencies believe that if it's not being used for 5 years, then it's no longer prior converted. Prior, again, I believe it's November 1985, but it also has to have been certified by NRCS, Natural Resources Conservation Council, as prior converted cropland. One of the tricks is that under the data security provisions of the Food Security Act, NRCS can't share that information with even other federal agencies or states. So it can occasionally be a surprise to EPA if they bring a violation for converting a wetland, and so the owner of the land pops up and says, aha, it's prior converted. It's really hard to find that out in advance. But that's one example where we do have, it might even be November 28th, but don't count on my morning memory on that, but of 1985, but there is a specific date. With respect to relatively permanent, Sackett didn't talk more than the Rapanos opinion by Justice Scalia did on what relatively permanent is meant. In his opinion, Justice Scalia dropped famous footnote 5, which comes from a statement that it has to flow at least relatively permanently in order to be a WOTUS. And then it drops footnote 5 and says, by saying relatively permanent, I don't mean to exclude waters that dry up in times of drought, or waters that flow only for part of the year, but flow seasonally. And so that's language that EPA and the Army Corps have used since the Rapanos opinion to try to unpack that relatively permanent a bit more, that it does need to flow at least seasonally. And initially, some field staff said, using great math about the level I operate at, that, oh, there's 12 seasons, there's 12 months, there's 4 seasons, a season must be 3 months or 90 days. And started saying if it was 89, that made it a tight, firm, definition with an in and out line. And science doesn't support that, nor does the language in the relatively permanent opinion from Justice Scalia. And so the agencies then and now continue to say that will depend on from area to area. What's seasonal in Alaska is different than seasonal in Alabama or in Arizona, even though they all begin with A. The 2023 rule, as revised, does clarify that water from snowpack, even though at one point it fell from the sky and thus was precip, can be considered relatively permanent if that snowpack melts off at a seasonal level. That had been a point of confusion prior to saying that. In terms of continuous connection, it's generally thought of as related to what relationship a wetland after Sackett has to have with the nearby relatively permanent water in order to be considered adjacent and thus WOTUS. As I mentioned, it is interesting that it doesn't have to be a continuous hydrologic connection. So in other words, you don't have to have a perennial flow connecting a wetland to the relatively permanent water that can serve as a basis for that wetland being jurisdictional. That connection can itself, in effect, be seasonal. And what the agencies have been looking at, and I think the person speaking after me may be able to say this much more and how this plays out in Montana, but you look for indicators that water has flow, that there is a connection, that it goes from that wetland to the relatively permanent water. So we all know areas that can be delineated wetlands might have water below the surface, or they might have water only part of the year. In California, for example, vernal pools are very seasonal, only around in the spring. And so it was thought that it would be odd to require a perennial connection from something from a wetland that itself isn't always articulated on the landscape year round. So that we go for continuous. Let's see, what other words? There's plenty that are ambiguous.
You covered the ones I was thinking of.
Okay. Yeah, and one thing that is important to remember, although it seems terribly important, a lot of the factors like ecological importance on the landscape or relationship of the wetland that you're looking at and its ability to, for example, collect contaminants that then no longer flow downstream to affect the integrity of the traditional navigable water. Those significant nexus-related factors are no longer relevant for jurisdiction, but it might be enormously relevant for why you care and why folks in the state might want to continue to look for non-federal ways to protect those waters. But the permanent standard is the one you're supposed to use. Significant nexus for jurisdiction no longer is. And that's really clear holding in the Sackett opinion.
Thank you, Donna. I think
Mhm.
we probably have time for one more. Anyone else with a question?
And my
Linda?
contact info is on the slide, and I think, Steve, you're going to share those with folks, right?
Yes,
So
I
if you
will-
have questions that come to mind after, feel free to reach out to me and I'll get back to you.
I will be sharing the slides and we are recording the presentations, and Sage, I will talk with you about this and if you're allowed. And we will share those after the meeting as well.
Great.
Good morning, Donna. Linda Saul here.
Hi, Linda. Good to see you
Hi,
again.
I know you too. Thank you so much for helping us unravel this. The way my mind thinks, well, for one, it's only gotten more confusing in the 8 years I've been away from this. But the way my mind thinks is needing like a flow chart or a dichotomous key to stepwise through all of this. And I'm wondering if that's something that the association there is helping, maybe even in those two categories of pre-2015 and 2023 states.
Yeah, there does seem to be certainly decision points and factors that might aim you to the left versus the right. And I don't mean that in any political sense, up or down, whatever. And it seems like it would lend itself to a dichotomous key, but unlike, are they opposite or, leaves or not, here we don't have some clear information yet as to do we go left or right. For example, we don't have 89 days is not seasonal and 90 is, or anything like that. But there are factors, as I've been kicking around today, and also are in those materials that I listed on my slide as providing information from EPA and the Army Corps headquarters as to how to deal with this, that tell you, think about this and then decide if you go left or right. I kind of like the idea of trying a key or laying this out in one place. I may play with that a bit and see what comes up. But I think at this point, given the litigation's ongoing, I anticipate that Corps and EPA headquarters would be really concerned. Their lawyers' heads would blow off if they were to issue such a thing that sounded more definitive than they're comfortable being right now. And that litigation, by the way, is why we don't have clear statements that are definitive about how to implement the pre-2015 rule consistent with Sackett. Is they really don't want to lose the litigation and start over. And I, for one, am delighted to no longer be at EPA and having to do yet another definition of WOTUS if indeed they lose. But anyway, I'll mess around with that and share with you if I come up with anything that seems more helpful than confusing.
Great, thanks. Just thinking about some tools to help my colleagues here. Appreciate it.
Okay, thank you. And while I load up the next presentation, if there is another question for Donna, please feel free to ask. Donna, we're going to, we're going to hide you and put up this next presentation.
That sounds good. Now let my cat, who's been pawing at my leg, hop up and block the view. I want to thank you all again for letting me come in and talk with you. I'm really interested in what states are trying to do to protect their wetlands in light of Sackett. And the variety is interesting, but it really proves that the suggestion after Rapano, since virtually no state filled the gap explicitly, well, it's because states don't care, is a conclusion that is just completely wrong. There's enormous state energy trying to figure this out now. And I looking forward to the presentations coming up, to hearing more about what's that energy articulating itself as in Montana. So thank you.